Good evening, ladies and gentlemen. And Lee, thank you very much for the very gracious introduction, and I appreciate the opportunity to be here with our distinguished candidates tonight. No pressure, gentlemen. Any flub you make tonight will be seen and heard from here to Red China, so don't worry about it. Nothing to be afraid of. It's okay. It is a great honor to be back here once again at George Mason University. I thank the law school very much for hosting this very important debate between our two distinguished candidates for Attorney General. I have been asked to say just 1 or 2 minutes about the office. I can tell all of you that it is a great honor to be the Attorney General of Virginia. Sometimes we in Virginia get very eccentric about the governorship, and everybody knows that the high honor that the governorship is. But I want you to know that for an attorney, it's very, very difficult to be the office of Attorney General of Virginia. It is about the most highest honor you could give a lawyer here in this state. I say to you very bluntly and honestly that we should always remember when we take this office that the Attorney General doesn't always get to be elected governor of the state of Virginia. And therefore, one should do that job to its highest possible benefit, its highest possible quality, because that may be the last big job that one ever gets. And that job deserves the very best that one can give, because it is, in fact, the legal opportunity for the state of Virginia. The office itself advises the governor. It advises all of the agencies of the Commonwealth, represents the officers of the Commonwealth. It is entitled to give its own legal policy and to establish its own legal policy, just as Lee said. We established a policy with respect to religious freedom at the University of Virginia, which is a doctrine that stands to this very day at all of our public universities. We didn't have to do that, but that was an example of, in fact, forward-looking public policy. The Attorney General of Virginia is independently elected. He does not sit in the cabinet of the governor. He is independently elected and has an independent obligation to the people of Virginia who elect the Attorney General. He is not part of a ticket. That is, frankly, a great strength. And so we know that elections do give you great strength. The office is a highly professional office. My goal there was to create the highest possible professionalism, the new facility, a complete reorganization of the office at that time to make it make complete sense for the people of Virginia. And then, of course, the church burning issue has been offered as an illustration of the bully pulpit that the Attorney General can have when you go forward and you're talking about criminal activities in the Commonwealth of Virginia. In that particular instance, it was an example that then we were forwarding to other southern states as well, as we established a national public policy out of state offices. So these are the powers and the opportunity that you have as Attorney General of Virginia, and it is a great honor and a great opportunity to serve. We have some great rules tonight. We will be following a good series of questions. I'm going to ask 2 questions after they have done their opening statements. And then we have quite a number of questions that you have asked. So we will look forward to asking some of those questions as well. No hissing or booing, none of that? Okay. None of that? Okay. We'll exercise, I think, a great opportunity for you all. So, with that being said, we will now begin with our opening statements from our candidates, and I believe we're going first on the opening statement in alphabetical order, and the first opening statement for 3 minutes will be Rob Bell.
Good evening. So everybody, I am running for Attorney General because I believe our Constitution is in grave peril. And the reason our Constitution is in grave peril is because Barack Obama does not accept the limitations it puts on him. He just doesn't. And if you elect me, every day I'll wake up, I'll put the newspapers out, and I'll say, all right, what did he do last night? Is it constitutional? And if not, what are we going to do about it? But that's no longer enough. It's no longer enough to play defense, and the reason is, of course, that we have lost too many of our liberties already. Now, this is a lot of lawyers in the room, but just for everybody's benefit, I hope you understand the Obamacare decision is about so much more than health care and insurance and exchanges. It is direct authority for the government to make us buy something. And when I was in law school, we studied there were two great expansions of federal power. They said right after the Civil War, there were the constitutional amendments, there was the New Deal. We have just been through the third great expansion. 100 years from now, they'll be studying 2012 as the third great expansion. And the worst of it is, it happened on our watch. We are responsible for this. So I believe we have a moral obligation to take our Constitution back, and a moral obligation to give our kids the same Constitution that our parents gave to us. That's our obligation to fulfill. Now, if you have any doubts or any questions about my commitment to doing this, I'd ask you to look at the Property Rights Amendment that passed last year. Now, the story of that was the Supreme Court in 2005 said that the government could take property from one person and give it to another through eminent domain, not for a road or for a school, just because they liked the second person better. So here's what we did. 2007, I had a resolution to make a new constitutional amendment in Virginia to protect property rights. It failed by 4 votes. Came back again the next 2009. Failed in committee. Came back in 2010. It didn't even get out of the House, and we were going in the wrong direction. And people did say, find something else to do. It's a waste of your time. Quit. But that's not what we did. We formed a broader coalition. I was in the House. Mark was in the Senate. We put a Democrat's name on the top, and it passed by 1 vote. 1 vote, got out to you all, and you all passed it last November. Thank you. That is the commitment I will bring to fighting for the Constitution. I look forward to your questions tonight, and thanks for coming. Thank you.
Mark Obenshain.
Governor, may it please the court. Well, it is great to be here. I want to thank the Republican National Lawyers Association, George Mason University. I thank all of you for coming out this evening to listen to Rob and me talk about the Office of the Attorney General and our vision for this office. And I have to tell you that the Office of the Attorney General of the Commonwealth of Virginia has never been more important. We have a crisis that we are facing here in Virginia and across the country. And Rob's right. We have a president who has demonstrated time and again over the past 4 years that he is unrestrained by constitutional limitations. He is unrestrained by statutory limitations as well, and it has too often fallen to the attorneys general across the country to be the ones who stand up and fight back and draw that line in the sand and say no further. I am proud of the fact that our Attorney General has followed in the tradition of Jim Gilmore over the course of the past 4 years, and that Ken Cuccinelli was the first Attorney General in America to stand up and fight Obamacare. I'm proud of the fact that he has pushed back on the environment and pushed back against the EPA, whether it's on coal, whether it's on agriculture, or whether in Northern Virginia it's on stormwater. These are fights that must be fought. The fights that are coming up are going to be fights over our right to work law here in the Commonwealth of Virginia and fights over our Second Amendment rights. I've been fighting fights for 25 years as a practicing attorney, running 2 law firms for 10 years in the Senate of Virginia, and I've been recognized both in the private sector and in the legislative work that I've done by the sheriffs and Commonwealth's attorneys they both recognize me as their Legislator of the Year for my work on public safety. By the Farm Bureau, Rob and I worked since 2005 on the eminent domain constitutional amendment. He carried it in the Senate, or in the House. I've carried it in the Senate, and we fought together, linked arms, even with Democrats, building a coalition to get that passed. Furthermore, by the Family Foundation of Virginia, for standing up for family values consistently during the course of my 10 years, during which I've chaired the conservative caucus of the General Assembly, and by the Chamber of Commerce for standing up for free enterprise here, particularly in Northern Virginia, fighting the project labor agreement requirement that was attached to the extension of the metro here in Northern Virginia. And I might add, the guy who fought on the other side of that, on the side of the AFL-CIO, a guy named Mark Herring. We're going to see a lot more from Mark Herring. Ladies and gentlemen, I appreciate the opportunity to visit with you. I'm running for Attorney General because I believe that we have to continue to fight for our freedom. It is not enough for us to draw a line in the sand every year. We have to expand the realm of freedom that we live in, that we are going to pass to our children. We have that solemn obligation, and I thank you for your attention and the invitation to be here.
Gentlemen, thank you very much. I'm going to ask the first question, and I believe that the way that this is going to go is that Rob Bell answers first, I think, and then Mark Obenshain. So my question is to follow on those opening statements. Each of you have highlighted the fact that you see the Attorney General's office as adversarial to the federal government. That's what you have just indicated, and you warmly accept that proposition. My question to you is, what about state policy? What about state legislative initiatives? What about the question of the law and how the Attorney General can influence the direction of the Commonwealth out of the Attorney General's office? What is your vision for the operation of the Attorney General's office? When you sit down in that desk the day after you're elected, Rob, what are you going to do? What directions are you going to try to take the office in, and of course through that the Commonwealth?
I think that the issue is, what are we going to do? First thing is not very exciting. Ken Cuccinelli has hired a wonderful appellate lawyer. We need a wonderful appellate lawyer working in-house to continue on the work that he's doing with regards to the federal actions with the Constitution. We have got to form a long-term systematic plan to dismantle Obamacare. The model should be what the NAACP did after the Plessy v. Ferguson decision, especially in 1940 on, where they said we will dismantle it piece by piece, brick by brick, until the thing falls altogether. We need that same model in Virginia. In terms of the day-to-day affairs, your job is to analyze the law in a fair way. What that means is it's not very exciting. It's not what you're going to hear Mark and I talk about a lot. But we are given opportunities to say, this is not a constitutional law. And I think you're seeing that right now with regards to the transportation plan that was proposed by the governor, tweaked. The Attorney General has said, it's just not constitutional. It doesn't matter if it's a good idea or bad idea. It doesn't matter if it fixes something or something you don't like. This will not pass constitutional muster. I think that's the job. You have to tell your client, which is the legislature sometimes, and the governor sometimes, and the agencies sometimes, things they don't want to hear. Now, they don't have to do it, and I'm afraid we're going to see over the next few days what happens when the Attorney General says something is unconstitutional, and there's a political pressure to do something anyway. But your job is to call them straight, to say, listen, fellas, this will not work. The courts will strike this down. This is unconstitutional. It doesn't matter if you like it or not. I think that's the job.
Mark?
The question, I think, deals with the day-to-day operations of the office aside from the dealings with the federal government. And it is not always going to be a job that lands you on the front page of the newspaper. However, it does touch the lives of Virginians in every capacity, every day. The Office of the Attorney General provides day-to-day advice to every agency, department, board, and commission within the Commonwealth of Virginia. And one of the toughest things for a lawyer to do, and those of you who practice law will appreciate this, those of you who are going to practice law, I hope you listen to this. One of the most difficult things to do sometimes is to tell your client no. And every once in a while, I know this will come as a surprise, government gets in the way of things that free enterprise, that the private sector ought to be able to do. We need to make sure that the state government is not interfering unduly with business in the Commonwealth of Virginia. We've got to perform that regulatory function, but we've got to focus on achieving the possible. We can do this in multiple ways. One, by reining in regulations in the Commonwealth of Virginia, the #1 job killer here in the Commonwealth of Virginia. Number two is giving blunt advice to the boards and agencies of the Commonwealth of Virginia who too often get in the way of progress and economic development. And it's not enough just to throw up a roadblock. Let's help these businesses achieve what they ought to be able to achieve. Second, we've got to work to protect the most vulnerable. We've got to be proactive in crafting legislation that fights things like human trafficking, elder abuse, that promotes cybersecurity here in the Commonwealth of Virginia. These are things that will be the day-to-day operational aspects of this office that I will focus on from day one.
Well, let's do a quick follow-up, Rob. You've heard him give that talk quite a bit. Is there anything you disagree with? Anything that he says he wants to do with the office?
No, of course not.
Is that everything okay?
We've reached a point where we can give each other speeches, if you haven't figured it out yet. And, I think that, everybody understands the Attorney General doesn't actually write new laws. That's not you. We're both legislators now. We're used to writing the laws. The Attorney General interprets them. But you do have, and Mark referenced this, an extraordinary bully pulpit for topics that are involving the office. The most obvious would be crime. And for the Attorneys General over the years, every year they've identified a criminal topic. And so Bob McDonnell focused on sex offenders and came up with the first version of Jessica's Law. We just passed the final version last year that says you get a life in prison if you rape a child who's 12 or under. That started with Bob McDonnell as Attorney General. This year, Ken Cuccinelli focused on human trafficking and helped us craft bills, one of them was mine, to focus on those men that cruise in, middle schools and shopping malls looking for vulnerable girls to try to bring them into a life of prostitution. You can use the office in so many effective ways to move policy, even beyond providing just legal advice, and I think it's something we should do.
So you don't disagree with anything that Mark's been saying either today or on the campaign trail, right?
Not tonight.
Okay, Mark. You've heard him give his talk today, and you've heard him on the campaign trail. What do you disagree with? Anything with Rob that you would disagree with?
Hey,
No?
if you're looking for Rob and I to mix it up, both of us are looking forward to being the guy who's going to be mixing it up with Mark Herring in the fall. Rob and I, it's a dirty little secret here that we actually get along with each other. We actually work with each other. We actually have linked arms on half the bills that we're going to talk about here on the legislation to put away those who would rape a child. Rob was the House sponsor of that. I was the Senate sponsor of that. The eminent domain constitutional amendment. We worked together on that. Both of us think that we are the best person to carry this message of conservative values to the people of the Commonwealth of Virginia. I've been fighting this fight for all of my adult life, and I believe in building coalitions. I wish that there were enough people who had a big R attached to their name, that all we had to do was go out there and wave the Republican flag and we would automatically win. It doesn't work that way, ladies and gentlemen. We have to build coalitions. We have to reach out to like-minded Virginians, whether they are independents or even Democrats, who have been left behind by the President of the United States and the organized Democratic Party. We've got to take this message, build these coalitions in the style that Jim Gilmore used to do and understands how we built coalitions and we changed Virginia. We've got an opportunity to change America, but we've got to build coalitions in order to be able to do that.
You guys are no fun at all. Okay, well, all right, we'll try this one on for size. This time, I think the order of answer is Obenshain and then Bell. In the past General Assembly, the issue came forward as to the expansion of Medicaid in the Commonwealth of Virginia under Obamacare. The legislature, under the proposal of the governor, passed a device called the Medicaid Innovation and Reform Commission, a subset of legislators plus a couple of other stray appointees who would then determine whether or not certain standards had been reached, and if they had been so determined, then at that point they would approve an expansion of Medicare under Obamacare. There's an exercise of discretion that is built into that statute. They have an obligation to, yet the Constitution indicates the entire General Assembly, all the senators and delegates, have to vote on the appropriate approvals and appropriations in order to do this kind of expansion. Now, some would say that this is not constitutional. Some would say, on the other hand, that this is just a ministerial function. Some would say that the General Assembly and the governor were trying to avoid responsibility for the expansion of Medicaid under Obamacare through the use of this device. What do you guys think about that as a matter of law?
Governor, I couldn't tell from the tone of voice what you think. The actions of the General Assembly in that matter. Look, both Rob and I voted against that legislation, and I oppose it as a matter of law. I have grave concerns. I've read the Attorney General's opinion concerning his views as to the constitutionality of this kind of a delegation of authority. But let me back up and make one thing perfectly clear. This is a two-part process. Number one, do we want reform and efficiencies in Medicaid? You're darn right we do. We have to turn Medicaid upside down, shake it till all the rats fall out of this process. And I want to encourage reform. I think that we've got to do that. Second part of this question is, are we going to take responsibility as a corporate body, the General Assembly, the House of Delegates, and the State Senate, for an expansion of our Medicaid program that adds 400,000 new participants to it, or are we going to find somebody who is going to make that decision for us? Well, look, $18,000 ain't a lot of money, but that's what we get paid for making these decisions, for serving in the General Assembly and in the Senate and the House. This is our job. Our job is to make those determinations as to whether or not we're going to be expanding a program like Medicaid. It is not appropriate as a matter of policy, for the General Assembly to punt to a panel of 5 or 10 in order to avoid that responsibility. And I share many of the same concerns articulated by the Attorney General in his opinion in addressing the legality and constitutionality of making that kind of a delegation.
That's a direct answer. Rob?
Let me tell you why you should care. The President has offered us $9 billion, us being Virginia collectively, to expand our Medicaid rolls by 400,000 people. That's the offer. Medicaid has expanded by 478% in the last 20 years. It is literally the pressure on the budget that leads to so many other pressures that we see. There's no other item that's that big that is growing that fast. So this really, really matters that we get it right. Okay, so that's the backdrop. So what happened was the General Assembly initially said, and so the President is offering us this poison apple, this beautiful red poison apple, and asking us to take it. And the General Assembly initially said, no, you've got to prove to us that we've got all these reforms, you've got to prove to us that it's going to work before we will take the money. That was the original House position. You can study it, you can come up with whatever plan you want, you can show it to us 3 times, but you cannot take the money until we vote for it. That was the right approach. Instead, the final compromise, when the House and Senate got together and made their compromise, was to create the MIRC, Medicaid Innovation and Reform Commission, which will consist of legislators, and when they say it's good to go, we take the money. It never comes back to us for another vote. If this doesn't terrify you, you're not thinking through it. This amount of money is so vast, the pressures it'll put on our budget are so high, it is a terrible idea. Now that's just the policy. Well, let's talk about the legality of it. The Constitution says basically you cannot cede certain authority away. You cannot delegate that to another group that has discretion to make the decision. So there's 2 possibilities about this commission. Number 1, they have discretion to make the call of when to take the money. That's unconstitutional. We just can't do it. Second possibility, they don't have discretion. It's just ministerial. Their job is just to see if the check boxes are done. That's even worse. That means when certain things are done, we have to take the money. Either way, legally, this is a terrible setup, a terrible idea. It is exactly intended to do what Governor Attorney General Gilmore said, which is to make sure there's no politician's fingerprints on it when Virginia takes $9 billion, which by 2017 we have to start paying a share of it. We just shouldn't do it. I hope that it gets struck down. Thank you.
Well, just a very quick follow-on, Mark. If this thing that you all have denounced occurs and becomes law, with or without your votes, and you become the Attorney General, you will have to defend that in court. Can you do that?
Well, as you know, Governor, you have a choice as to whether you have to defend it or not. The first obligation of any attorney is to make a judgment as to whether within the bounds of good faith he is able to make a judgment or determination that there is a good faith basis for mounting a challenge to or mounting a defense of a measure. If the Attorney General determines that there is not a good faith basis in the law or in fact for defending that statute, the governor is going to have to make some alternate arrangements necessary to defend that statute, and that may very well wind up being the case.
Rob, you want to follow up on that? You just made your statement regarding this, but if you become the Attorney General, you got to go to court and defend it. What are you going to do?
Well, it's already too late. I was on the floor of the House And Bob Marshall came up afterwards and said, if you're the Attorney General, this will be Exhibit A that I'm going to use against you when you argue. Now, I said the same thing on the floor before we passed it in a failing attempt to tell my colleagues that this was a bad idea and they shouldn't do it. I would have the same concerns that Mark has raised. Now, it passes. I'm fortunate enough to be Attorney General. I'll sit down with staff. The lawyers in here know this. The law students will figure it out soon enough. You don't always like every client. And so we will certainly have bills that I would never have voted for that we have to defend, and I would try to see if I can make a good faith effort to do it. But I have to say this one will be harder than most. Thank you.
I'm going to turn some attention now to the questions from the floor. Each of you will recognize if you may put this in. Talk to me for a minute about how you're going to handle a difference of opinion with the governor. If you disagree on a legal position, the governor wants to take a position, and you're the Attorney General for the state of Virginia, and you disagree with the governor, what are you going to do? The answer this time goes first, I believe, to Rob, and then then Mark.
For the most case, he's the client, you're the lawyer. And the best example with Attorney General Cuccinelli was actually George Mason, was the gun case of George Mason, where he would certainly have, as a policy matter, not supported the policy that was imposed, but it was his job to defend the case. And so I would use all of my rhetorical abilities to try to convince the governor that what he's about to do is a bad idea. And I think if that governor is Ken Cuccinelli, I think it'll be very easy. I think we will agree on most everything. If that governor is Terry McAuliffe, God save us, I think we might have, there's something that the lawyers call a client control problem. And usually it's the other lawyer and you are negotiating and you have to admit that that's a very reasonable thing that you're offering, but I'm afraid to say it, Mark, but we have a client control problem here, and he's very sympathetic and gives you more time to work it out. No, sometimes there'll be a client control problem, and the governor or the agency will not do, or the legislature will not do what you advise them to do, and you still have an obligation to defend them as best you can, with the hopefully very narrow exception that Mark mentioned. Thank you.
You know, as with the General Assembly, the vast majority of the work that is done by the Attorney General in conjunction with the executive branch is not very political. It does not have a lot of political taint, as is the case in handling 95% of the legislation that goes through the General Assembly. Stuff that is regional, it's solving problems that people across the Commonwealth agree need to be solved. And the Attorney General typically is going to be able to work with the governor. But there are going to be situations in which, for a variety of reasons, either the governor decides not to use the Attorney General because of a political difference. The governor has the ability, under certain circumstances, to retain his own counsel in order to pursue a cause of action or to defend a certain action. And likewise, the Attorney General has some discretion to decline on the basis of determining that somebody else is better situated to provide the defense or to handle the litigation, or because he doesn't believe that there's a good faith basis for handling the matter. So there are going to be occasions, even in situations, as Rob pointed out, in which we have a governor and attorney general of the same party, in which that is inevitably going to arise. Hopefully it will never arise with Governor Cuccinelli and one of the two of us, but chances are a situation will occur which will necessitate making some alternate arrangements, and it is not the end of the world.
Next question from the gallery here, and I think this will be answered first by Mark and then by Rob. Would you join the Shelby County, Alabama challenge to Section 5 of the Voting Rights Act? Should Virginia have to continue to obtain pre-clearances for all of our voting changes?
Yes, I would join, and no, Virginia should not have to obtain pre-clearance. You know, we've got a small subsection of the states of the Union that are being treated differently. And it is time for us to end this different treatment. And it is time for Virginia to escape this process, which requires us to submit virtually everything we do with respect to changes in election law to the United States Department of Justice. I mean, we make minuscule changes. I serve as chairman of the Privileges and Elections Committee. Last year, we changed the law. Get this. Until last year, you could, for 2 weeks during the year, actually go in and register to vote. Of course, you don't need a photo ID or any ID to register to vote. You turn in your voter registration form and turn around to leave and say, oh, I need to vote absentee. And you would get an absentee ballot, no ID required whatsoever. You fill out that absentee ballot, throw it in the ballot box, and that egg is scrambled. You're never going to unscramble that egg. The United States Department of Justice came to Virginia, engaged in the interview process, interviewed me because I was the patron of that legislation, and expended great administrative resources to figure out whether or not we were going to be allowed to adopt that election integrity measure. We just passed a bill that I put in and have been fighting for since 2005 to require people to show a photo ID in order to be able to vote. And we're going to be in a fight, I predict, with the United States Department of Justice, even though people can get that ID with absolutely no barrier. They will come down, and we will have a difficult time getting that through.
The question is, would you have joined the Shelby County, Alabama challenge to the Section 5 of the Voting Rights Act?
Yeah.
Do you believe we should have to pre-clear?
No, I share the same position as Mark. I mean, if you're not involved in the election process, you would be astonished at the microscopic level of scrutiny we go under for every itty-bitty legal change, everything we want to change. It's just, and the reason is, of course, the history of this area, the reason the law was passed in the first place. I think the time has passed, but it is still productive. I think Virginia is capable of maintaining voter security, avoiding voter fraud, and I would absolutely join the lawsuit. I too have been interviewed by Eric Holder's people over a bill that I worked on last year. And again, this was, oh my gosh, we spent a lot of time preparing for it. We had to hire an attorney. We had the Attorney General's office taking their time up too. If there was something it was accomplishing, then maybe you might say that there's still a need for it, but there's not. This year alone, we passed, there were, I can think of 5 voter fraud measures. The one that Mark mentioned with photo ID, which is a great bill. I'm glad the governor signed it. We wanted to do more background checks on the voter list to make sure that we don't have felons slipping through, because in 2008, we know there was a lady who was a felon. She registered, she voted, we caught her only afterwards, and her vote was in the pile. Thank goodness it wasn't a one-vote election, but her vote counted. And we prosecuted her, but who cares? The point was to get the voter rolls better beforehand. We're going to do a better job of checking people in multiple states. If you have moved in the last 5 years, you're probably registered in 2 states. You don't mean to be, you didn't do anything wrong, but they just don't take you off the old rolls when you take the new ones. Last year, a lot of parents found that their kids were still registered in Virginia, even though they went to college and are pursuing a career in Houston. They're still actually registered here. We're going to try to fix that with the states that will work with us. And then the one of all the bills that is still on the governor's desk, unfortunately, is one of mine. And it would say that the Attorney General can directly prosecute voter fraud cases rather than having to be invited in. Is this bizarre part of the law that says that if you, a citizen, bring a videotape of someone voting for you, I don't know how you could do this, but if you could bring that to the Attorney General's office, he would still have to say, I can't, I'm sorry, I have to be invited in. That's sitting on the governor's desk. We hope he will sign it, or I'm sorry, I hope we will take his amendments and he'll sign it and it'll become law. Thank you.
Well, just a very quick follow-up, Mark. Okay, so Shelby County prevails, pre-clearance goes away, and then either the General Assembly, the one in which you used to serve, or the local elected officials pass some rules, regulations, or laws, and the African-American community comes to you through its representatives as Attorney General and says that it is impinging upon their right to vote. There's no more federal government to look at that anymore. What are you going to do?
Yeah. You know, we've got an obligation, just as a prosecutor has an obligation to pursue justice, and that doesn't mean always getting a conviction. Sometimes it means walking away. You know, what we're talking about with these revisions has nothing to do with deterring people from voting who are legally entitled to vote. We want to remove every possible barrier to the exercise of the franchise. And if the General Assembly passes legislation that violates the rights of citizens of this Commonwealth of Virginia to exercise the franchise, the Office of the Attorney General should step in and defend the rights of Virginians. Now, none of the bills that we've talked about do that. None of them do that. The legislation, the rhetoric that has been spouted has been absolutely unbelievable. You know, the rhetoric over the photo ID bill, you know, for example, the Democratic Party of Virginia put out a press release the day that legislation passed. Delegate Herring, who's chairwoman of the Democratic Party of Virginia, said it was a heinous measure. It was un-American. Well, let me tell you, Jimmy Carter proposed that following the 2000 presidential elections. And James Baker, as part of the Carter-Baker Commission, said we need to make sure that we have voter confidence in the integrity of our election system. And it is a delicate balance. We need to make sure that integrity exists in the election system, but people will not have confidence if we are turning away people from the polls who ought to be able to exercise the right to vote. It is a delicate balance that I am committed to. There is not one legal voter in the Commonwealth of Virginia I want to prevent from voting. I want every single one of them to have the ability to exercise that right to vote.
All right, Rob, I'm going to restate the question. Okay, so Shelby prevails. There's no more federal government to look over this. The General Assembly or a locality, but let's say the General Assembly passes a rule, which, by the way, the Attorney General passes on. The initials go right on the document before it goes to the governor approving it. And the African American community comes to you and says, our right to vote is being impinged. What are you going to do?
I'd like to build off what Mark said. I mean, if they are complaining about the work that we have done, they're wrong. The right to vote is not the right to push a button. The right to vote is to have your votes counted in choosing our next elected official who leads our country for 2 years or 4 until we get another chance to vote. I mean, that's what the right to vote is. And so to have that vote offset by someone who should not vote is to take the right to vote away. Now, there have been a series of case law on the reforms we're talking about. And so let me just walk you through. There are 2 different ways you provide photo ID, and I know a lot about this because I had another bill. Mark's was the one that passed, by the way. Mine did not, but the 2 different bills. You can do it like Georgia does it and have it done through the registrar's office. You can do it as Texas proposed doing it, essentially through equivalent of, let's call it the DMV. The issue is it has to be free. Now, the reason Texas was struck down was the license, the ID was free, but you had to have a birth certificate. And so the court said it's not really free. You're making someone pay for the birth certificate if they don't have one. Let me tell you how complicated this was. Mark was smart enough to run his through the registrar. I actually tried to do mine through the DMV. We said, well, let's see. You have birth certificates that are local. Those are easy. What about the ones from Idaho? We had to figure out a way to set up a fund and pay for the funds from Idaho. What about the person who is American, born in Mexico? What about the person who's born in Mexico, becomes a citizen? It's all got to be free. But if it is free, it does not impinge on their right to vote. Now, because the existing law is in effect, the federal law is in effect, we are still going to have to jump through all of these hoops, spend a lot of Attorney General's money and time to defend this law, which does nothing but say, we have to have a photo ID to vote, and we'll give you one for free if you don't have one. It's a dumb law. We should work to strike it down. Thank you.
Next question from the audience is about taxes. And the question is, and I'm reading it, as Attorney General, what can you do on the issue of taxes in the Commonwealth? Will you support full repeal of the car tax? I didn't write that. And the second one, in the state legislature, have either of you supported repeal of the insidious car tax? Or do you support repeal of the insidious car tax? I didn't write that. That's from you guys. Let's see, I believe this time it is Bell first and then Obenshain.
First off, yes, I opposed the car tax when the time came to freeze the rollback. And if you remember, what happened was every year they're rolling back a little more. And then as part of the big Warner tax increase, he A, raised taxes, and then B, stopped the rollback, froze it at 70%, except it's even worse than that because he actually didn't freeze it at a percentage. He froze it at a fixed amount of money, $850 million. So every year it gets a little smaller, but it's even worse than that because counties grow at different rates. So I'm in a fast-growing area, and it's pegged to the county. So it's not even 67% statewide anymore. It's, who knows, 61% in Greene County, and more than that in places where the population isn't growing. It's stupid to freeze it. It's stupid to freeze it this way. I did have legislation to try and fix parts of it, and that failed. Sorry. The big issue as Attorney General would be you don't get a vote. You're not one of the 100 delegates or 40 senators. You do have a bully pulpit. And at a minimum, you can make sure they go through the constitutional steps before they raise your taxes. This gets back to what's happening right now with the transportation tax that Ken Cuccinelli has opined is unconstitutional. They just can't do it. And the reason they just can't do it is because it doesn't have anybody's fingerprints on it. It just has the state government saying it's going to happen. They're going to impose a higher tax in Northern Virginia and Hampton Roads. They're just picking it out by geography. Now the governor has come up with a patch, which would do it by criteria, that may fix the constitutional issue. It's no longer based on geography, it's based on traffic counts and things like that. That raises the problem that now the whole state is theoretically subject to it. So instead of it just letting Hampton Roads fix their problems, Northern Virginia fix their problems, you've now set up criteria that someone who wants to get in can try to get themselves in. I think that's the kind of things you can do as Attorney General. Thank you.
God bless Jim Gilmore and the repeal of the car tax. You know, it's more than a slogan, and it is something that we ought to follow through and finish. I believe that, you know, when you look at our patchwork of taxes in the Commonwealth of Virginia and across this country, we've developed a strategy for taxing, one in which we incrementally increase 100 different taxes so that nobody notices that they've been the recipient of one large tax increase. We look for ways that we can tax people 100 different ways. And you look at what we just did with the transportation package. You know, part of the reason it was put together that way is that it was an opportunity to spread it out among a lot of different little taxes so that the full impact isn't going to be fully realized, even though the Farmer household and the Obenshain household, the Bell household, we're going to get stuck with the full package. And I believe that we really need, you know, what we really need to do is take a good hard look at tax restructuring. And by that I mean we need to do exactly what Jim Gilmore did and eliminate some taxes. We need to look at ways that we can fight the imposition of new taxes. And you know, if the General Assembly, if a future governor believes that we need to raise taxes, you know what? They ought to propose it. They ought to stand behind it, and people ought to be able to feel it. And if they can make a case for it, then they're not going to be punished for doing it. But enough of this death by 1,000 cuts. And the Attorney General of Virginia has an opportunity to exercise that bully pulpit, the opportunity to use the platform that he's been given in order to affect the direction of the public debate on issues like taxes, as our Attorneys General have done many times in the past. And if I'm elected Attorney General, you can count on me doing that.
I appreciate the nice remarks, but under the photo ideal, I'm voting for both of you, so don't worry about it. Don't have to say anything like that again.
You don't live in Illinois.
Next question is goes back to your opening statements, but I'm going to add a little something to it. The question really from the audience is: do you believe the Commonwealth has a legal obligation to protect the rights of its citizens from unconstitutional federal laws like gun control and healthcare laws and so on like that? But I might ask it a little different way. When you stand up and take the statewide oath, just as you did as legislators, you're going to also swear to uphold the laws of the United States, as well as the laws of the Commonwealth of Virginia, and the Constitution of the United States, as well as the Constitution of the Commonwealth of Virginia. But yet both of you have been very vigorous today about your opposition to certain federal statutes and federal regulations and federal initiatives. How do you tell the difference between what you would uphold and what you wouldn't? And I think we start with Obenshain this time.
Yeah. Well, look, as Attorney General, as an attorney in any practice, you have to go through the analysis necessary to make a decision as to how to address a particular issue. And number one is the question of whether a federal action is constitutional. If the action is constitutional, that is not at the end of the inquiry. We have actions that have been taken by the Environmental Protection Agency repeatedly over the course of the last 4 years that are not unconstitutional actions, unless, of course, you consider acting without statutory authority to be unconstitutional. Repeatedly, the Obama administration, Lisa Jackson, the EPA, have adopted regulations that have no foundation in statutory authority. Just a couple of months ago, Attorney General Cuccinelli joined Texas and a number of other states in challenging the trans-boundary emissions standards, the regulations that were adopted by the EPA seeking to restrict and regulate power plant emissions crossing state lines, like they can do that, right? And what the federal court found was that there's no statutory authority that granted the EPA the ability to do that. That was the 6th occasion upon which the EPA has been found in the past couple of years to have exceeded the statutory limitations. We have a lot of opportunities to challenge illegal and unconstitutional federal actions. And as an attorney, as Attorney General, occasionally we are stuck. We are stuck with telling our clients, our constituents, our party faithful that it is bad policy, but it is not illegal. We're going to have to fight it on the policy front. And a lot of these fights are fights that we're going to have to fight and win on the policy front.
Ron?
The issue about unconstitutional federal actions is it doesn't matter if it's a good idea or a bad idea, or if we like it or don't like it, or think it has a good outcome or a bad outcome. This is the list of things they can do. This is the constitutional list of enumerated powers. You've got the belt and suspenders of the 10th Amendment. If it's outside what they can do, they just can't do it. It doesn't matter. They just can't do it. And one of the jobs of Attorney General, probably the foremost single job, you represent Virginia. You have to stand there in the breach and say, you cannot do that. I represent Virginia. We will stop you as best we can. So I think that's the first thing. The second thing would be, if you are clever and thoughtful, you can work with the General Assembly to get standing in cases where you might otherwise have difficulty. And the issue, this is a legal doctrine, but it says, when can the state intervene? The state can't intervene every old time that it wants to. You have to have standing. We had a bill, the House Bill 10, which was the bill that said it's the Virginia Healthcare Freedom Act, and it just said we will not have Obamacare in Virginia. It was a Virginia law. What it meant was, as soon as the feds passed the Obamacare statute, Ken Cuccinelli could, within the hour, filed his challenge. He was the first one to file the challenge, and he did it by working with the General Assembly, getting in front of this and saying, let's set the field up. We don't have to wait for this to come forward. Let's set the field up so that when it passes, we're prepared to play defense right away. And then the third thing, and this is a longer play, much longer thing, we need to be proactive about this. Again, we have lost too much liberty already. Thurgood Marshall, 1940, with Plessy v. Ferguson. Does everybody know this? The law students all know this, but probably most people don't. They recognized that the Supreme Court was dug in on separate but equal. And they said, we want to have black kids go to school with white kids. All right, the separate can't seem. We just can't seem to get through the separate. Let's go with the equal. And so first they started at the law schools, then they went to grad schools, and by the time 1954 arrived, the entire paradigm had shifted by case after case. They dismantled it, passed 9-0. They're able to overturn it. We can do the same thing with Obamacare in Virginia. Thank you.
Well, the next question from the audience, and this time I believe we do Bell first, then Obenshain, is that right? Next question is, and I'm going to add a little to it. You'll follow, the question is, will you follow, well, it's referring really to Attorney General Cuccinelli and saying that his critics say he's an activist Attorney General. The question, of course, from the audience is, are you in the same mold or would you be different? I think I'm going to ask you a little differently. Lee, I believe that I might have been the second Republican Attorney General ever elected in Virginia. I think Marshall Coleman, then me. I think that's all. Since then, there has not been a Democrat that's held the office of Attorney General since Mary Sue Terry. Not one. So you got a big burden here to carry, guys. You got to keep that going. So I'm going to ask you this question to follow on with this. Let's take the last three. Never mind Coleman or me, and nothing said about me. Let's take instead the last three Attorneys General: Cuccinelli, McDonald, and Kilgore. How would you be different from any of those in the approach that you would take to the office? Now, how would you be different? Okay. Bell first.
So they were three very different men, and they governed the office in three very different ways. I would actually say that Kilgore and McDonald were more the same. And let me just tell you my thoughts. They were both former prosecutors, and I think they saw the office, and I think you could look at what they did, as an extension of their career in law enforcement. Top cop, top prosecutor. You look at their signature achievements. Again, Bob McDonald made the first chance at Jessica's Law to try and extend penalties to sex offenders. That was something he was very proud of. Kilgore did the same back when he was Attorney General. Ken has taken a different priority, and his priority, I think it's safe to say, has been the constitutional work that he's done. Now, it may be that just from a background standpoint, Ken was not a former prosecutor. They were. It might be temperamental. I think it's a signature of the times. If you look at who was president when Kilgore and McDonald were working, it was Bush. Now, we might have complaints about Bush in this room. I certainly have complaints about the work he did, but nobody thinks he treated the Constitution with the same derision that Barack Obama does. Ken Cuccinelli has risen to the occasion. He has put his boots on, and he has said, this is not someone who's just a little different from us or has a different approach. This is someone with a fundamentally different approach to what federalism means. We need someone to stand up to him, or there will be no federalism left. That's what Ken Cuccinelli has done. We elected Barack Obama, our president, in November. He will be president for the first 3 of the 4 years that Mark or I get a chance to be Attorney General. So long as he is in the White House, you have got to have an Attorney General who will stand up to him just the same way that Ken Cuccinelli has. I don't see these as mutually exclusive. I think you can pursue good, hard law enforcement initiatives while you're defending the Constitution. But I think you've got to have that constitutional approach, at least while Barack Obama's in the White House. Thank you.
Mark?
You know, the Attorney General's office has 380 employees, $36 million budget. It has responsibilities that cross the spectrum. There is not one part of the job that you can look at and say, that's not important. Every part of the job is important and affects Virginians in some fashion or another. And we've got to have an Attorney General who, number one, understands the great challenges of our time. And I do believe that the number one challenge facing the Attorney General of Virginia is standing up to an overreaching federal government. That will remain the number one challenge as long as Barack Obama remains President of the United States. And hopefully it will end and we will have a very boring tenure for the next Attorney General of the Commonwealth of Virginia following the Obama administration. However, and that is my priority, that will be my priority, standing up to federal governmental overreach. However, we have to have a good administrator, somebody who has experience in running a law firm. I've never prosecuted a case, so Rob's right. Ken Cuccinelli and I have never prosecuted a drunk driving case, never will. But I've run law firms before. I've run 2 law firms, one with about 75 employees and one with that I started about 10 years ago with about 50 employees. And I understand that the responsibility of the Attorney General is to set the tone for the office, to guide the policy, to make sure that the jobs that touch Virginians all over the Commonwealth of Virginia, whether it's in our schools, whether it's taxpayers of the Commonwealth, whether it is consumers who need protection, whether it's the elderly that need protection, that all of those jobs are done. And you have my commitment to make sure that we do those jobs. And you know, each person brings different qualities to the office. I don't think that I would be a clone of any one of those people. I sat with Ken Cuccinelli. I helped him manage his transition as he became Attorney General. However, you know, we're different people. And we'll handle the office of the Attorney General with a different style, maybe not a different focus.
This time Obenshain answers first, I believe. Article 1, Section 15A of the Virginia Constitution sets out that marriage in Virginia is the union between one man and one woman. and only that is valid and recognized by the Commonwealth. And in fact, no, the Commonwealth or the political subdivisions shall not create or recognize any legal status or relationship of unmarried individuals that intends to approximate that, nor shall the Commonwealth create or recognize any other union, partnership, or other legal status to which is assigned the rights, benefits, obligations, or effects of marriage. That's the law of Virginia. Now, we have a case that's before the Supreme Court right now, according to the question from the audience, is to explain your legal opinion with respect to the questions that are before the Supreme Court. California Prop 8, which is presumed to define marriage in California. And I'll add one more question, since Mark, and you're answering first. Okay, so never mind what happens in the Supreme Court. You're now the Attorney General of Virginia, and gay Virginians come to you and demand the equal rights under the law, to be treated equally under the law, to have the same rights, obligations, and responsibilities, and the same ability to marry just as anybody else would as a citizen of the Commonwealth. What are you going to do?
I believe that marriage is an institution to be entered into by one man and one woman. I support Virginia's marriage amendment. I supported it, and I continue to support it.
Yay!
I believe that Virginia's marriage amendment is constitutional. I do not believe that there is a basis for challenging the constitutionality of Virginia's marriage amendment, and I would not have a moment's difficulty in standing up and defending it in court. With that being said, I want to make it very clear that it is critical for us to stand up to protect the rights of all Virginians. The marriage amendment does not create discrimination. It does not. It deals with the recognition of an institution called marriage. But we need to make sure that Virginians' rights, their privacy, is protected. And there is nothing in the marriage amendment that addresses or prevents people from entering contracts with one another, signing wills, leaving property to one another, buying houses and owning property jointly, signing advanced medical directives, and designating the person of their choice as the grantee of the powers under an advanced medical directive. We need to make sure that we protect the rights of Virginians not to be subject to discrimination on any inappropriate basis in the conduct of their daily lives, in the conduct of their businesses, in any inappropriate ways. Now, we need to make sure that that is not institutionalized. Do I support creating an independent cause of action? No, I don't. I think that employers need to be protected, and we need to make sure that we achieve that appropriate balance.
Saved by the sign. Rob?
Well, I voted for both the statute, the law in Virginia that made it one man, one woman as marriage, and I voted for the constitutional amendment, and I voted for it when it came out. And this issue is not directly before the Supreme Court, but I think everybody understands that it could be. In other words, if the Supreme Court takes an expansive view of the cases in front of it, it can do one of three things. Number one, it can use a procedural hurdle to strike down the California Prop 8 and nothing else. There's actually an issue about whether the person who is defending it has standing to do so. If the court wants to be very, very narrow, it can rule on that basis. The second is they can address DOMA, the Defense of Marriage Act. That's the federal act that does two things. First, it says that states are not required to recognize another state's marriage law if it has something other than one man, one woman. It also says that federal law, for purposes of federal benefits and other issues, will be one man, one woman. They can strike that down as a federal issue and leave it on a state-by-state basis. Or they can take the most expansive ruling and say, we no longer believe under the United States Constitution that you can have a marriage law that specifies one man, one woman. Those are the three possible outcomes. Everybody who's watching this believes it hinges on one man's decision, Justice Kennedy, will make his mind up sometime in the next 6 weeks and thereby set social policy for the entire country. And anybody thinks this is what the founders intended, or how this is supposed to work, they're out of their minds. This is not, and in fact, Justice Kennedy has said that. He has said, we do not make these decisions best when we let the court do it. I'm aware that there is substantial discussion about this issue. You have, I think it's up to 9 states now that have some form of this, some form of gay marriage. Virginia does not. The proper way for this to be addressed is through the political process. Somebody who's smarter than me can predict where we will be in 50 years, but that's the proper way to do it, not to have the court make these decisions for us. Thank you.
So to follow up, Mark, it is your position that marriage is not a right that applies equally to all Virginians without regard to sexual preference?
You know, there's something called substantive due process, in which courts substitute their policy judgments for the judgments of the legislative branch. It's been happening for an awfully long time. And it is important for us to fight back, to pursue a judiciary that sets aside, as the federal judiciary gives lip service to setting aside this notion of substantive due process. No, I don't believe that it is illegal or unconstitutional for the state legislature to adopt a statewide policy defining the institution of marriage. And I do not believe that the Supreme Court should strike it down. I do not believe that it will. However, I was kind of wrong about Obamacare. And I hope that the Supreme Court decides not to substitute its policy judgment in this instance for the judgment of the various states.
So, Rob, your position is that marriage is not a right that applies to all Virginians without regard to their sexual preference.
I don't think it's up to the court to make this decision. This is not the role of the court to act like another political body. We have an executive branch, either the governor or the president. We have a legislature that sticks its finger up in the air and says every 2 years, what do the people want? We don't need a third. We don't need a court to say, golly, the polls seem like this, or there's 9 states that do and 41 that don't. The court's job is supposed to be to interpret this. Is the law constitutional or not? That is supposed to be the role of the court. And where you see where they have gone astray is when they're thinking too hard like politicians and not enough like constitutional analysts. That's when they get in trouble. So the most corrosive decisions they have had, and we might have a disagreement about which those were, but the most corrosive decisions they have had is when they were untethered from the Constitution and just said, people seem to be headed that way, people seem to be moving that way, we'll just get there a little faster.
Yeah.
Now, I had the great privilege of studying under some of the best constitutional scholars at the University of Virginia. I just had blind luck to have them. They were terrific, but here's what they pointed out. If the court was so brilliant, if it could always figure out what the Constitution meant, it wouldn't wait until the public almost got there before it changed the law. You wouldn't abolish the death penalty in 75, you would have done it in 1842. But somehow they got there only when a bunch of other states were moving that way. They wouldn't have taken up abortion in the late 60s and early 70s. They would have done it in the 1920s. Why did they get there? Because that's where the public has almost gotten to, or the public's about to get to. That's all the court does when it tries to divine what the politics ought to be. That is not the court's role. It's our role, for better or for worse, so that there's accountability. And if you want to change something, you change the politicians, and they change it for you. We don't need a court to do that. Thank you.
I believe this time it's Bell and Obenshain, is that correct? Or is it the other way? Bell and Obenshain. Here's the question for you. Attorney General Cuccinelli recently said that conservatives need to change the culture of corrections and stop throwing away the key. Now, for many terms now, the Attorney General of Virginia has been a policy leader in the issue of crime and law enforcement in the Commonwealth of Virginia. Do you believe that criminal penalties are too harsh in Virginia? Are there areas of Virginia penal code where you believe the penalties should be lowered? So we'll start with Rob.
Okay, the myth about prosecutors is that we hate all the criminals, and you're wrong. We have a much more nuanced view because we spend more time with them. And so I have people that come up to me on the street, the conversation always goes the same way. Hey, Mr. Bell, you remember me? Yeah, that's always somebody that I've locked up. It happens at parades. It happens at the grocery store. There are two kinds of criminals. There are those who are evil, And you got to lock them up because they are going to keep hurting people until they die. There are those who are knuckleheads. And the knuckleheads are a much bigger category, and we have to figure out ways to get the knuckleheads going in the right direction. If you don't know what I'm talking about, it's your brother-in-law, it's your neighbor's boy, it's someone who keeps getting in and out of trouble. Now let me tell you what we're doing because it's kind of exciting. There is this thing we can do with them. Half of all the people going into prison in Virginia are on probation the day they walk in, which means probation is not working. We're not doing a good job of getting them going in the right direction. We are stealing, lock and stock, a program from Hawaii, and here's how it works. When you violate probation, when you're late for your appointment, when you have a dirty urine screen, when you cuss at your boss and get fired, they don't wait 6 weeks to get you back in front of the judge. They get you the very next morning. Now, that sounds easy, but you got to get the lawyers lined up. You got to get the judge to leave time on his docket. He doesn't know for who, but he's got to leave time. You got to have the probation officer able to arrest them on the spot so they can be taken literally from that lousy plastic chair and brought over to the judge the next morning. The big surprise in Hawaii has been the drug use. We figured this would get them there on time. We figured this would get them to stop cussing the boss. It turns out, of the drug users, which is the primary problem on probation, there's a larger category of social users than addicts than we thought. We thought this wouldn't work for the drugs. It's actually working for the drugs. If we can get 1/3 of this that they're getting in Hawaii, where the re-arrest rate is down to more than half, if we can get that to work, we can change the culture of correction, not by letting dangerous people out, and not by saying we don't care when you break the law, but by saying we will get you going in the right direction and leave the bed spaces for the evil. That's the goal.
What do you think, Mark? You think we should stop throwing away the key? Do you think the criminal penalties are too harsh in Virginia?
Well, you know, we're Republicans. We believe in individual responsibility, but we're also people who understand that there has to be grace. And, you know, back in 1993, as was pointed out, we went through this process in which we examined what had become of our correctional system in Virginia. It was pretty disgraceful. We had gotten to a point where first-time convicted murderers were getting out of prison for murder after 4 years. And we had a liberal and lenient parole system that was out of control, absolutely out of control. And we took hold of that. Not we. It was Jim Gilmore, George Allen, and the people who were in the General Assembly at that time took control of that and got rid of, abolished parole in the Commonwealth of Virginia, and created a situation in which if you did the crime, you did the time. That is important. One of the things, though, that comes with that is every time there's a heinous crime, every time there is a wreck involving texting or something else, there is a rush to the General Assembly in order to increase the penalties that attach to that crime. And it's easy to get that legislation through. It's sometimes really hard to stand up to that legislation. And we get to a point at which we really need to seriously evaluate and make some difficult decisions as to whether the penalties are stiff enough. And sometimes we have to say, yes, absolutely. And when we get to the question of grace, we do have a significant issue. And we started this policy debate this year dealing with restoration of rights. I applaud the governor and the attorney general in spirit. I don't agree with their approach. I believe that just as in our faith walk, that grace is something you ask for. It doesn't need to be the most articulate request. You have to ask for it. And we ought to ask something in return. That's a short period of good conduct. I would be for restoring rights, but not automatic and not immediate. Thank you.
We're coming to the end of the time. You might want to shorten up this, and I'll try to get in 2 quick ones. Just get your opinions on 2 issues. Number one, and I think this one we'll start with Obenshain. Do you have a position on payday lending in Virginia? There are laws in Virginia on payday lending. Would you alter them, uphold them, change them quickly?
You know, we just went through the process a couple of years ago of changing the laws on payday lending. You know, if we had no laws, there are going to be people who are always going to go to a lender of last resort. If there's a guy standing on the street corner who says, I will lend you money and I'll break your kneecaps if you don't pay it back, there are people who are so desperate for those reasons that they will accept those terms. We've got to provide people with some avenue. And I would have never opened the door to payday lending. That door was open When was it opened? It was opened by Governor Warner, I think, in 2000, 2001. And I wouldn't have opened that door. I thought it was a bad decision, unfortunately. I hope it wasn't yours, but in any event. But that door is open. And I think it's wrong to come in after a few years and simply outlaw a business that we invited into the Commonwealth of Virginia. I think that some of the restrictions that have been placed on that business are appropriate. And we need to make sure that we aren't victimizing a class of people, and we've got to make sure that we're not creating a cycle of dependency that people cannot get out of. And some of the reforms that have been adopted have been good common sense reforms that help people escape that cycle. And since it's here, I have not supported doing away with it.
Rob, Obenshain says that it's a bad law, but we're stuck with it. What's your view?
I'm always uncomfortable when people wearing ties and suits go to somebody and say, I know better than you how to make these financial decisions for your family. And nobody likes the payday lending. They've got terribly high interest rates, and many of them, if you have a credit card, you'd be a fool to use one, but there are people that do not have other options and do not have other choices. And I think that for us to stand in judgment and say, we will not let you do this even though you really want to, needs to be handled very, very carefully. Now, I did vote for the regulations to make it clear that if you're getting into this mess, we'll try to make it extraordinarily clear what the interest is, what kind of problems you might address. There's a rollover, try to stop people from getting into the habit of getting one, not paying it off, then getting the next one, not paying that off, and before you know it, you've got 4 or 5. But I really don't think if you're conservative, your goal should be to say, I know better than you what you're going to do with your finances. Thank you.
Last question. I've got a few more here, folks, and they would be really embarrassing to our candidates. I'm willing to do that, but I don't think tonight. I'll ask one last question. And this one, I believe, we start with Bell and then Obenshain. Do you believe that there are illegal aliens in the Commonwealth of Virginia? Do you believe our law? Well, you ought to see what else is here. We've got drones and everything in here. Do you believe there are illegal immigrants in the Commonwealth of Virginia? Do you think our laws are inadequate? What would you do about it? What leadership would you provide as Attorney General?
Okay.
Bill first.
So I think that the issue of illegal immigrants, in terms of what Virginia can do, which is obviously different than what the federal government can do, there's a couple things. The first is we can try to diminish the incentives that encourage people to come. So the first would be we have an E-Verify system to make it clear that someone's legal before you hire them. It's not very expansively used. It ought to be. The second is we can make sure that in terms of government benefits, which would be tax dollars that are spent, we don't spend them in a way that encourages additional people to come here. And I think the third thing would be as people are arrested for breaking our laws, we can work with the federal government as much as they will let us so that when we are finished with the judicial process, they can then be sent home. Now, I always use this example. In the mid-90s, when I was prosecuting in Orange County, we picked up somebody, and under oath, he admitted that he was not supposed to be here. And my memory was he got 30 days. It was a fight or something modest. And I literally picked up the phone and called INS at the time, and I said, what's the process, sir? I have somebody who said he's not supposed to be here. He's going to spend the next 15 days at our jail. How do I make arrangements for him to be picked up? And I think everybody now knows what he said. He laughed. He said, that's not what we do. It's just, are you kidding me? That was one misdemeanor in one person. There's no process. There's no arrangement. There's no anything. And so, to my knowledge, he's still living in Orange, having paid his fines and gotten off probation. I think that's a foolish system, but we have to have the feds work with us. And so what we do is we set up a system where at least we know which crimes will lead to deportation. And so that at least for those offenses, we can make sure that when someone is in fact picked up, we can get them into the pipeline. Thank you.
Mark?
A couple of things. Rob's exactly right. Basket of benefits winds up attracting people and creating an incentive for people to come to the Commonwealth of Virginia. We have a number of things that we have an opportunity to do, one of which that both Rob and I have worked for is denying bail for people who have proper cause to believe are here illegally. Also, I introduced legislation a number of years ago that would have revoked the corporate status, the LLC status of businesses that willfully hire and employ, willfully hire and employ illegal aliens. We need to remove the incentive both in the private sector and for those who are incented by the basket of benefits that we offer. I live in the Shenandoah Valley, and you wouldn't think of the Shenandoah Valley as being an area in which it's a challenge. Our schools have 45% kids who speak English or come from households in which English is spoken as a second language, 45% in my part of the Shenandoah Valley. But a word of caution here. I also live in a community in which a large percentage of those are citizens. These are friends, these are neighbors, these are co-workers, these are people we worship with who are going to be voting. And we need to be very cautious in our rhetoric and make sure that our policy is a common sense policy that does not incent the kind of conduct that we want to disincentivize. But we also need to make sure that our rhetoric acknowledges that we're a nation of immigrants. And we've got a long way to go in that regard.
We'll now move to closing statements, 3 minutes each, and that will conclude our debate tonight.